session. Justice Peterson presiding.
Thank you all very much. It's been reported to us that Mr. Walsh is having the similar type of struggle that all of us have been having with this transition to Zoom. And we appreciate y'all's accommodation and being willing to do this via Zoom. We've done this a number of times. We find it perfectly functional, though not perhaps ideal. Are both sides present and ready?
Yes, sir. Yes, Your Honor.
Okay. Well, then I'll call the case. Case number 0519-00440-CV. Obsidian Solutions, LLC, formerly known as Arco Ideas, LLC, versus KBIDC Investments, LLC. Thank y'all for being here to have oral argument here at the 5th District Court of Appeals. In one of your windows, you see a timer. Both sides have 20 minutes, then 20 minutes, and then 5. When you're down to 3 minutes in your 20-minute sections, it'll turn yellow. And when it turns red, finish your thought or finish your exchange with one of the justices if that is what is occurring, but try to wrap it up. And when you're on your 5 minutes, Mr. Walsh, you'll get a 1 minute yellow. Anybody, if there are no questions, then Mr. Walsh, you may proceed whenever you're prepared.
Thank you, Your Honor. May it please the court, the appellants would request that this court dismiss this case for lack of jurisdiction because this lawsuit and the claims asserted in this lawsuit are within the exclusive jurisdiction of the bankruptcy court. And we know this for 2 reasons. First, when you file bankruptcy, all of your assets, including any potential claims and litigation you have, are automatically poured into the bankruptcy estate. And there's only 2 ways for an asset to get out of the estate at that point. They are either administered by the trustee, either through a sale, an auction, or being included as part of a reorganization plan, or they are abandoned. And there are a couple of ways they can be abandoned. But in both instances, assets have been listed on the asset schedule in the bankruptcy. As one federal court put it, an undisclosed asset never leaves the bankruptcy estate.
Mr. Walsh, was this a Chapter 11 bankruptcy? Yes. Was this a debtor in possession bankruptcy?
Yes, this was a Chapter 11 bankruptcy.
Right,
but what happened was when the bankruptcy.
We're having some technical difficulties, but I think if I understood you, we agree this is a Chapter 11. But was this a debtor in possession Chapter 11, or was a trustee appointed in this case?
It was my understanding there was a trustee, Your Honor.
Okay. I'm sorry. Please continue. I apologize.
And I apologize. There's a lot of lag.
Yeah.
I apologize if I speak over you. I'm not intentionally doing it. What happened in the bankruptcy, and that's the second point, is if you look at the bankruptcy order, this was started out as a Chapter 11, but there were, I guess, apparently there weren't enough resources to create a reorganization plan. So after they had determined how much the creditors were going to get, they filed a motion to dismiss, and it was a conditional motion to dismiss. And if you look at that order, and I'm not sure if I can bring up, if I can share a screen, and I want to show it. Nope. In the order that the court had issued, the court had noted that the bankruptcy court was going to retain jurisdiction to enforce, interpret, and implement the terms and provisions of any order entered by any order in the debtor's Chapter 11. And one of the orders was that issue was an order called the sale order. And that was the order, it was a 31-page document that had listed out all of the terms and provisions related to the asset purchase agreement that's at issue in this case. And so what the court was saying in their dismissal. I apologize.
No, it's all right, Mr. Walsh. I think the last thing I heard was dismissal.
For some reason, For some reason, the people in my neighborhood decided to change the wiring on the internet today. I don't understand why they did that, but in any event, so if you look at the court order in the bankruptcy, it talks about the fact that the bankruptcy court is retaining the jurisdiction to interpret, enforce, or implement any of the prior orders. And one of them included the sale order, which was the order related to the asset purchase agreement. So the bankruptcy court in its order was specifically retaining jurisdiction to interpret or implement that asset purchase agreement. And that's important because that's a big issue in this case, is the interpretation of that agreement. So there are two bases for the bankruptcy maintaining jurisdiction. One is the fact that it wasn't listed as an asset, therefore it stays within the bankruptcy. And two, when you look at the order itself, and this is located at the end of Exhibit 11, and I submitted to this court this order yesterday by letter, just so they could have it for this hearing. If you look in that order and you look at paragraph 15 in conjunction with paragraph 5, those are the two provisions that you can look at. Does that answer the question?
Thank you.
Now, to counter this argument, the appellees have argued, one, that we can't rely on the bankruptcy documents because this court can't take judicial notice. And I believe that's wrong for the following reason. While this court is generally limited to the record before the trial court, there's one exception to it, and that's when this court's jurisdiction is being called into question. And that's what's being done here. And when this court's jurisdiction is being called into question, this court can look at extraneous documents. In particular, they can look at documents from other courts, records from other courts, and that would include the bankruptcy court. And the case I cited in my brief is a case called Freedom Communications versus Coronado. And that's a case where the Texas Supreme Court clearly indicated that when jurisdiction is at issue, an appellate court can look to the records of other courts to determine jurisdiction. Here, the court has to look at two documents, the asset schedule. I'm sorry, did somebody ask a question? Okay. The two documents that this court has to rely on are the asset schedules in the bankruptcy and the conditional order issued by the bankruptcy court. And this court can take judicial notice of both those documents. The other argument that was made that was that neither Blue Matrix nor KBIDC had knowledge of the potential claims before the bankruptcy. Knowledge does not matter. In fact, if you look at the Crane case that we cited, that was a case where the plaintiff had sued the defendant for personal injury. The defendant filed a motion for summary judgment arguing judicial estoppel, that it wasn't identified in the bankruptcy proceeding of the plaintiff. The judge granted the motion for summary judgment. On appeal, the parties were briefing to the court the issue of notice or knowledge of the claim, and the court said that doesn't matter. If it's not formally on the schedules, okay, the bankruptcy retains jurisdiction regardless of knowledge. The only issue is there an actual claim? And this makes sense because you can't have a situation where an investor in a company can put the company into bankruptcy, not disclose an asset that their claim is worth millions of dollars, and then somehow be able to obtain the benefits of that asset after the bankruptcy is closed. So knowledge is not an issue. Was there a question that I missed? Okay. So based on those two primary reasons, this court should dismiss the case for lack of jurisdiction. Now, there's one substantive issue I'd like to address, and that's the unjust enrichment. We're asking this court to set aside the jury's verdict on unjust enrichment. In a case where there's an express contract between the parties, the plaintiff does not have a right to recover inequity, whether it's a claim for money hadn't received or a claim for unjust enrichment. In this case, there's no dispute.
Back up a second. So your request is
Yes.
that we dismiss the case for lack of subject matter jurisdiction. What do we do
Yes,
if the
sir.
judge Presumably the trial court didn't have jurisdiction either, if you are correct. And so we would have to deal with that, and we wouldn't worry about this unjust enrichment thing, would we?
That's true, Your Honor. No, that's true. If this court finds that there's no jurisdiction, then it has to dismiss the case and has to void the judgment from the court below. In fact, according to the cases on this, once the court determines that there's no jurisdiction, it only has one thing it can do, and that's dismiss the case and void the judgment from the trial court.
Yeah, we got to vacate the judgment from the trial court, don't we? And then dismiss? I'm asking.
Yes, you do. And that's what we're asking for.
Yeah. Go ahead. I'm done.
I'm very sorry if I was talking over you. It's hard.
Life and interesting times.
Okay. I don't know if you heard my answer, but if you find there's no jurisdiction, this case has to be dismissed and the underlying case has to be vacated because the judgment would automatically be void because the trial court would not have jurisdiction. So that's the primary push that we have in this appeal is that issue we think resolves the case, and you don't even have to get to all these other issues on unjust enrichment or whatever the case may be, because the case goes away.
Mr. Walsh, could you respond?
But in the event,
could you respond to Applee's suggestion that you have waived any error related to the unjust enrichment claim?
in the trial court, Judge Moye, when he addressed the jury charge, when he did the jury charge, he read the jury instructions and then he instructed the attorneys that any jury instruction that was not included that we had put forth or that was included that we did not want put forth, any objection to that is considered and overruled, and he didn't want to hear any objections on those points. And, you know, at that point, in fact, when I raised this issue at the post-verdict motions, I made that argument that the Judge Moye had gone through and said all the objections had been made and preserved, and he agreed with that. It's the way he runs his court. In fact, when I think Appellee's lawyer tried to make some objections, he shut them down, saying those are all been made, those are all preserved. And I cited his statements to the court in my brief. I know that it may not be the usual way that judges do it, but that's the way Judge Moye runs his court. And so to the extent that the issue is, did the judge have an opportunity to address it? He did. And he decided that that's the way he was going to handle it. And so I did not include any equitable jury instructions. I didn't want equitable in jury instructions because it was an express contract in the case. There's no dispute about that. And when he included them in there, based on his instruction, the inclusion of a jury instruction that were different than mine, any objections to that were considered by him and overruled. I'm sorry, was there another question?
No.
Okay. In terms of the unjust enrichment, the one other point I'd like to make is that there was no dispute here that there was a contract. There was a lot of dispute about what the form of the contract was. If you look under Texas law, if there's an express contract, you can't recover in equity. That applies to both oral and written contracts, okay? And therein lies the dispute that we had. My client argued that there was a verbal contract to work with Kendall Harder to develop products, including the water toys and the sandwich machine, as well as the office. They argued that there was a written contract, and they believed the written contract was from a proposal that my client had sent them after they first started discussing this. So there was a dispute about the form of the contract. They thought it was written. We argued that it was verbal, okay? But it doesn't matter. Each party agreed that there was a contract. And the part of the record that the appellees cite to say that there was that we were contesting an actual contract, when you actually read the full text of that, you'll see that we're not saying there wasn't a contract. We're saying that we had a verbal contract, not a written contract. And when they tried to refer to Exhibit 5 as a written contract, That's what my client was contesting. So because there was no argument that there was a written contract, there should have been no unjust enrichment claim. In fact, when you read the jury instruction, it basically reads, the first question is, did my client breach their agreements on the water toys, the sandwich machine, and the office? And the jury said, no, we didn't breach our agreements. And then it said, well, now go to the last question and answer, well, was my client unjustly enriched? Okay, that is not in accordance with Texas law. And that's basically providing 2 bites at the apple on the contract payments. And all the payments in the case were all related to those 3 things: the water toys, the sandwich machine, and the office. In fact, if you look at their Exhibit 12 in this case, they identify the different points, those three items, and the payments made for those 3 items. Now, I would like to make one other point on that and relate to the argument that there was an overpayment. There was no overpayment. Texas has a narrow exception to this rule on express contracts that applies when someone makes an actual overpayment. So for example, if you contract with someone to provide services for $200, you provide the services and they pay $2,000, okay, that's an overpayment. Neither party has breached, but somebody's overpaid by $1,800. You can go after that money on an equitable claim. But if you provide the services and they pay you the $200, and then they argue after the fact they didn't provide the services, so you overpaid, that's not an overpayment. And the Edwards case is really clear on this point. That's actually a contract payment, but you have a contract claim, not a claim in equity. And that's what we have here. Because when my clients were terminated in March of 2014, they were still owed money. And Kendall Harder, for the next 4 months, was continuing to work with my clients to try to pay the money that was owed. And for 4 months, he paid an additional, I think, $25,000 or whatever it was. And when the company went to bankruptcy, they still owed my clients about $6,000, and that was adjudicated in the bankruptcy. And so the issue is, we were never overpaid. We were actually underpaid based on the invoices that we had sent out. And so in this case, they're trying to argue that they overpaid because they paid us for services and we didn't provide the services. Well, that's a breach of contract claim. That is not within that narrow exception overpayment. Was there a question? I heard a noise and I didn't know if there was a question. Okay.
Nope.
In terms of dealing with the unjust enrichment claim, I think the McAfee case is very important because that was a case where a party had agreed to provide extended warranty services for another party, and the original party was outsourcing those services. Well, when that company was destroyed in Hurricane Katrina, they couldn't provide the services. And so the company who had already paid the money sued for breach of contract and money hadn't received. On summary judgment, the court dismissed both claims. The case went up on appellate court, and the appellate court said there was a factual dispute about the contract claim because there was a factual dispute about the interpretation of the contract.
Last thing we heard was factual dispute about the contract.
Yes, if the factual dispute was determined one way, there would be no breach. If it was determined another way, there would be a breach. And the court said, but for the equitable claim, it doesn't matter which way it goes. It doesn't matter whether there's a breach or not a breach because there's a contract. So the court affirmed the dismissal of the equity claim. And that's what we have here. We have a contract claim that the jury had determined whether we did or did not breach the contract based on whether it was a verbal contract or a written contract. That was all tied into the contract. None of that changed the fact that you can't recover an equity when there is a contract, and all the payments were made subject to the contract. But in any event, none of this really matters. I raised those issues just to address it for the court. None of that matters because it goes back to the very simple fact that The bankruptcy retained the jurisdiction in this case. And because the bankruptcy retained the jurisdiction of this litigation, then this court should only has one, if it determines that that is correct, it has only one option, that is to dismiss the case and to vacate and void the judgment from the trial court. Thank you. Are there any questions?
Any other questions?
Nope.
Thank you so much, Mr. Walsh. We appreciate it. And Mr. Terrazas, whenever you're prepared.
Thank you, Your Honor.
Thank you.
May it please the court. After a jury trial and multiple rulings by the district court, Arco Ideas has now raised for the first time numerous objections to the trial court proceedings below. The facts are that KBIDC has proven and a jury found that Arco held money that belonged to KBIDC. Whether that's determined to be unjust enrichment, another equitable claim, such as money hadn't received, or anything else, that was properly awarded to KBIDC. In addition, the trial court improperly granted a motion for directed verdict on KBIDC's fraud claim and money hadn't received claims, because there was far more than a scintilla of evidence that was presented at trial to support both of those claims. Further, despite the uncontested evidence, the jury improperly concluded that no damages were caused by Arco's breach of the non-competition agreement and that Arco did not breach its contract. Finally, Arco's plea to the jurisdiction is without merit because it raises a capacity issue that's been waived. The bankruptcy case was dismissed, not confirmed, and Arco relies almost entirely on evidence that was never presented to the trial court. I'm going to start, Your Honors, with the unjust enrichment claim, but I'm happy to start with any topic that you would like. In terms of the unjust enrichment claim, Arco was paid for significant portions of the projects that it never completed. That resulted in Arco being paid tens of thousands of dollars more than the parties agreed based on the work performed. In Plaintiff's Exhibit 13, the jury relied specifically on a number that was provided and the testimony provided from Scott Goodwin, which was Arco's representative, of the amounts that were paid beyond what was supposed to be paid for the work that was performed.
Well, what do we do with the no breach finding in response to question one? I mean,
in what way, Your Honor? I'm sorry.
Well, the jury found that the contracts weren't breached.
Yes, Your Honor, which could have meant that the jury found that there was no contract at all. The jury could have found that it was missing some sort of element that they didn't breach. But the jury did find that KBIDC that Arco was unjustly enriched.
Yeah, okay, all right. So as lawyers, we love to parse words. And so, but the question says, do you find from opponents of the evidence that Arco failed to comply with the agreements? Which kind of sounds like that's a statement that there are agreements. Is
Yes,
that,
sir.
am I misreading that?
No, Your Honor, you're not misreading that. And what I would say is, Your Honor, to that, again, there's an exception in terms of unjust enrichment in and of itself, where even if there is a contract, if there are overpayments and there's other equitable reasons why, then the jury can find unjust enrichment and award damages from that. And again, Mr. Walsh never objected to the unjust enrichment claim that was presented, whether before the court's instructions or after. And the first time he objected to that claim even being in was after the judgment was already rendered.
But
And there were never any special exceptions that were issued for that.
Is that not the type of thing that can be raised for the first time in a JNOV?
No, Your Honor, it can't. And actually, this court has found that it is waiver under the Texas Rule of Civil Procedure 90 and 91. Special exceptions have to be raised before the jury is charged. And when you have a jury question on the subject, an objection has to be raised to that before. It's not something that can be raised for the first time on a JNOV after a jury has rendered its verdict.
Okay.
And Your Honor, I would point the court to its decision in Benema, and that's Benema v. Builders Carpet, where in a similar case, it said that the trial court on a JNOV erred in disregarding the jury's finding awarding damages for unjust enrichment. Your Honor, that's similar also to the Clark v. Or excuse me, Your Honor, in the Duru case, the Richardson Hospital Authority v. Duru case, and the appellant relies heavily on the Galvez case, which cites to this Duru case. And even though it acknowledged that unjust enrichment was not a cause of action, it still construed unjust enrichment as an equitable claim for the return of money. And Your Honor, that's what this court and other courts have done. It's highlighted in the Newington case from the Northern District of Texas that's explained that oftentimes, even when courts have determined that unjust enrichment may not be a standalone cause of action, it's construed that claim as an equitable claim and awarded damages on other equitable theories. Your Honor, that's similar to what happened in the McCullough case from this court in 2014, where it sustained a judgment that because the plaintiff had proven the equitable claim of money hadn't received on the principle of unjust enrichment. Your Honor, the evidence supported and the jury found that there was damages that KBIDC had based on ARCO's actions and the amount that it had received beyond what it was contracted, agreed that what it would take for the performance that it rendered. Your Honor, we believe that that sounds in unjust enrichment and money hadn't received. And we believe that the trial court, if nothing else, was remiss and erred in dismissing the money hadn't received claim on directed verdict.
Doesn't unjust enrichment and money hadn't received basically do the same thing? Aren't they both just equitable opportunity, equitable remedies for money that you shouldn't get to keep? And if that's true, how were you harmed if you got unjust enrichment and not money hadn't received?
And Your Honor, we're not. And this is, and I apologize if I was confusing there. If the court affirms the unjust enrichment damages, then the money hadn't received claim is not necessary at all. In the trial court, it would be a harmless error for the trial court to have dismissed that on directed verdict. And again, that goes back to the McCullough case and other cases that this court has had that said that even if it's not unjust enrichment, that we construe it to be another equitable claim and money hadn't received would fall in there. So yes, Your Honor, thank you, because I apologize if I was not precise about that.
Thank you.
And Your Honor, Your Honors, I will move on from the unjust enrichment claim unless there's other questions there. I want to talk a little bit about the fraud claim. So KBIDC presented evidence that ARCO misrepresented its engineering capabilities, misrepresented the project, or excuse me, the progress that it was achieving as the project was going on, and it misrepresented the time in which it would take in order to complete the tasks. Evidence also showed that each one of these misrepresentations were false. ARCO was not a firm of engineers like it had promised. It did not complete any of the work that it was hired to do within the time frame represented or at the cost represented. And when ARCO finally did produce some work product, it turned out to be what the testimony was of worthless junk. In those misrepresentations, the evidence showed that they were material as well. Testimony showed that the KBIDC's predecessor would not have hired ARCO if it would have truthfully disclosed its engineering capabilities and experience. It also, the testimony showed that KBIDC would not have continued to retain ARCO if it had truthfully disclosed its progress on the assigned projects. Your Honor, and then KBIDC also showed that there was damages associated with each, with its fraud claims. So Your Honor, there was far more than a scintilla of evidence as to each one of those issues. And ARCO's only challenges are assertions that these statements were not verifiable facts or they were just opinions, but of course, representing one's engineering capabilities, representing the progress that has been made on certain projects, and representing the timeline for when it would be able to complete the tasks when it knew it couldn't are all objectively verifiable, and the evidence bore that out at trial. And Your Honor, the ARCO has already also made an argument on ratification, effectively a ratification argument. The problem is that the ratification defense was specifically excluded by the trial court. And that's in the third reporter's record at page 4, line 23 through page 8, line 7. And so it can't make an argument now that because KBIDC's predecessor continued to pay after any point that somehow ratified the conduct, that affirmative defense was waived. And either way, that affirmative defense doesn't hold water. You can bring a fraud claim for damages that were caused regardless of whether or not payments were made. And the testimony was that payments were made without knowing whether or not the work was actually performed. Your Honor, very briefly on attorney's fees, I'm not sure that appellant is actually challenging those or not, but of course, KBIDC can get attorney's fees for defending a declaratory judgment action, did so here. The court awarded those fees, and so they are proper. Your Honor,
was there a stipulation as to fees?
I'm sorry, Your Honor.
Was there a stipulation about fees?
Yes, Your Honor, there was. In terms of breach of contract, going into that, Your Honor, we believe that the jury's finding was clearly against the great weight and preponderance of the evidence. There were contracts that were presented. They were presented to be contracts. Your Honor, I think we lost a justice.
Yeah, I think we've lost one. Can we, I see that we're, there we go, we paused. Let's wait and see if she can get back. Strange world we're living in, isn't it?
Yes, Your Honor.
Well, while we're waiting, I'm going to go fill up my glass with water. I'll be right back.
Yes, sir.
Justice Peterson, I'm trying to check to see if I can get
Sure,
hold of her,
sure.
okay?
Oh, you're fine. I assume these guys will wait.
Okay, I think she's gonna make it. She's trying to log on right now, so just give her a few more minutes.
Stop. Go on. Oh. You got it. I've got a really upset neighbor here. Doing this, he's ready for me to play with him instead of working. All right, let's get out of here. Come on.
There we go.
Uh-oh.
All right, sorry, y'all.
Hey, Mandy. Right, check. Mr. Terrazas, we apologize for these technical difficulties. It's got to make Mr. Walsh feel better, though. So,
Doing my part.
yeah. So,
It's all good. Thank you. Thank you, Aaron. May I proceed?
as soon as
Oh, yeah,
Just-
I'm sorry.
ready, yeah, go ahead. Thank you.
Okay, thank you, Your Honor. Your Honor, in terms of breach of contract, there's a valid contract. There's evidence that a valid contract existed between ARCO and Blue Matrix, whether or not that was written or oral. Blue Matrix performed by paying ARCO. ARCO breached by failing to complete significant portions of the projects within the timeline provided by the contracts and delivering, again, what was testified as being worthless junk instead of functional prototypes. And KBIDC incurred damages as a result. And all of those things were proven at trial. I did not see anything in appellant's briefs that suggested or challenged any of those things. And therefore, the evidence established each element, and the evidence was so against the great weight, or the jury's finding was so against the great weight and preponderance of the evidence as to be manifestly unjust, and therefore a new trial should have been granted in terms of the breach of contract action. Your Honor, in terms of the damages for the non-disclosure breach as well, the jury found a breach of the non-disclosure agreement, but did not find any damages there. Those damages were uncontested, both at trial and here on appeal. There was multiple different exhibits, multiple different statements that were made, lots of testimony concerning damages associated with the breach of the non-disclosure agreement. And so, Your Honor, again, we believe that the jury's failure to award damages there was against the great weight and preponderance of the evidence to be manifestly unjust. Your Honors, the last issue that I would like to briefly touch on is the plea to the jurisdiction issue. Again, with the primary issue that's being raised here is capacity, that Mr. Walsh was claiming that that someone else, the trustee or Blue Matrix, was the proper party to bring these claims. And that's a capacity issue that this court has noted in the Highland Credit Opportunities case. That was something that appellant failed to plead and failed to plead properly, did not raise that. And so therefore that argument has been waived. But even if we look at the asset purchase agreement itself, and this is the district court found, and that wasn't challenged, the court specifically said that it finds that the asset purchase agreement does give authority to the plaintiff for the advancement of the suit. All of those claims were tied up into multiple different portions of the asset purchase agreement that assigned all goodwill, choses in action, causes of action, judgments, actions, claims and rights against, claims and rights of any kind against others. And Your Honor, that's in the asset purchase agreement. It was part of the trial, which is in the Sixth Reporter's Record at page 89 is where most of those citations are found. And again, ARCO, I'm sorry, Your Honor.
Was a plan ever confirmed?
No, Your Honor, it was not confirmed.
It was a Chapter 11 debtor in possession. Never confirmed.
I believe so, Your Honor. In terms of when you're asking, is the debtor in possession Chapter 11? We never delved into that much. We didn't delve into it at all in the trial and at any other point. I believe it was not confirmed though. That's clear.
Was it converted to a trustee? Was the DIP converted to a trustee?
Your Honor,
Liquidated plan?
Your Honor, again, I apologize. I do not know the answer to that. What I do know is that with this asset purchase agreement and the sale, that the bankruptcy was dismissed.
Were these claims ever listed on a schedule?
Are you talking about the specific claims against ARCO, Your
Yes.
Honor? No, Your Honor, they were not specifically listed on the schedule. There was a block of KBIDC purchasing all claims from Blue Matrix and the other entities that were there against any parties that were related to any of the assets.
Yeah.
And Your Honor, getting to that point though, what the case law is that it is the debtor here that has the responsibility to list the claims, so that if the debtor goes through a bankruptcy and it is confirmed, then the debtor cannot thereafter bring the claims. And that's very different here. What Mr. Walsh has never cited, and I haven't been able to find any case law to support it, is that if a third party purchases assets out of bankruptcy, that they would somehow be stopped from being able to bring claims that might not have been listed on bankruptcy schedules. And the reason for that is more of an equitable sort of thing. When a third party is buying assets, it's not their responsibility to list the assets on a bankruptcy schedule. That's the debtor's responsibility to do so. And whether or not the debtor does so can't thereafter stop a separate party, a third party, especially here, again, when a bankruptcy is dismissed, because all the assets then revert back to the debtor themselves, or in this case, whoever had purchased the assets from the debtor. And so therefore, here we have a situation where none of the assets remain with the trustee and none of the assets remain with the bankruptcy court because the case was dismissed in and of itself.
Bankruptcy court had to approve the sale, didn't it?
Yes, Your Honor, and it did.
It has to assure itself that it's getting the best value for the creditors in that, doesn't it?
Your Honor, I don't know what the bankruptcy court's obligations are, but that sounds right. It needs to ensure that it's getting fair value at least.
Right. And to assess that, it needs to know what assets are actually out there. Right.
Not necessarily, Your Honor. I mean, it has to know, I think, what some of the major assets are, but I don't think that the bankruptcy court needs to ensure it's informed about every single asset that might be there. Generally speaking, in my experience, which is limited, Your Honor, in bankruptcy, which is why it's hard here to try to, after a jury trial, to try to argue this type of thing. But my experience has been that the bankruptcy court simply takes a high level view. And if they have a willing buyer that's willing to purchase the assets for what appears to be fair market value, it does not delve into every single asset or try to find and ensure that every asset is presented necessarily in some sort of schedule.
So you can have an unscrupulous, and this is all hypothetical discussion. I'm not saying this about anybody. This is all hypothetical. You could have an unscrupulous debtor, doesn't list a valuable claim, has a buddy come along and buy the assets, and then they later pursue this unscheduled claim and split the deal, whereas the creditors get cut out of the deal. Is that what you're suggesting?
I think that would be fraud, Your Honor, and that would be fraud on the bankruptcy court, and that would be absolutely something that would be not justified, and it would go against the law. And I think that no one's raised any sort of claim or argument to suggest that anyone has committed fraud or anyone has done anything that was improper with the bankruptcy court.
But that's why assets and claims, lawsuits, are required to be scheduled, isn't it, to prevent that kind of thing?
No, Your Honor, they're to prevent the debtor from later trying to bring a claim that was not listed, that was confirmed.
Okay.
Not in the scenario you're talking about, Your Honor, where they get in cahoots with some third party. And Your Honor, I'm over time, but if I may finish. Not when the debtor gets in cahoots with someone else and then the someone else buys all the assets. again, there's no cases that I have seen at all that suggest that it is that a third party who buys all the assets somehow is stopped in some way based on what the debtor might have put on their schedules.
Thank you very much, Mr. Terrazas.
Thank you, Your Honor.
Mr. Walsh, you have 5 minutes whenever you're prepared.
Yes, and I apologize. I did not hear most of what Mr. Terrazas said at the end there. So I apologize if I repeat over something that was asked and answered. Couple points. One, this was not just some unknown third-party buyer in the bankruptcy. This was the largest investor for the debtor. And he was the one funding the bankruptcy. And so the reason why you have this rule, you have to list the assets, is you can't purchase an asset from bankruptcy unless it's listed. So they can have an asset purchase agreement, but it only gets to purchase what is listed. And that makes sense because bankruptcy can't be a shield and a sword at the same time. You can't use it to get rid of the creditors, but then when the case is dismissed, file a lawsuit that they say is worth millions of dollars and have the largest investor of the debtor get the benefit of that $1 million. And I checked quickly in the order that was dealing with the sale, and it looks like there was a trustee in this case. And the trustee had filed an objection to certain things. I could provide more to the court later, but I just wanted to note that I looked that up, and it looks like there was a trustee in that case. And that would be document 94 in the bankruptcy proceeding. There's a reference to a U.S. trustee. And this is not, and one of the things the Fifth Circuit makes very clear, and we cite in our brief, is disclosure cannot be underestimated. It's the most crucial part of bankruptcy. It's how bankruptcy can work, and it won't work if you're allowed to not list their litigation. And just so you know, this was one of 2 lawsuits they filed, and they didn't list any potential litigation in the bankruptcy. So in essence, what the investor here wants to do is to recoup potentially either 80,000 from this judgment or millions from what they're asking for, where that money should go to the creditors, not to the investor. Second, I want the court to remember one thing when you're talking about all of this issue about whether or not there was fraud. I think the jury saw through all of that because there was 2 key facts to remember. My clients were hired to develop products. They worked on 2 products. One was a self-sealing water balloon, which was an outrageous success. It won awards in New York for best toy of the year. It generated millions of dollars in revenue for the company. It was a great success. The sandwich machine was a great failure, and everyone admits that. They did their best. They created a couple of patents, which my clients were listed as inventors on by Blue Matrix, but it was a failure. But at the end of the day, they got one product that was great and one product that wasn't. That's not a bad record in this type of industry. And I think the jury saw that. And I think the jury also saw the fact that once my guys are terminated, there are text messages where the founder of Blue Matrix is saying to my guy, "Are you guys going to be okay? You know, how much do I owe you? I still want to pay you." And he
Are you back, Mr. Walsh?
Yes.
Okay. I'll give you a little extra time if you need it.
That's fine. So, so I think the jury looked at that and saw that at that point, when they were terminated because they're running out of money, Harder knew all the work they had done. He had known everything they'd done, and he continued to pay them. So there obviously wasn't a breach of the contract. There wasn't fraud. And I think the jury was confused here because the way the jury instructions were structured was, did they breach the contract? And they said, no, they didn't breach it. And then it says, go to question 5.
Last thing we heard was, it says, go to question 5.
was a brilliant point.
Sure.
The last point I was making is when you look at the jury instructions from the jury, they were told, did they breach the contract? And they answered no. And then the jury instructions said, now go to the end and answer the question, was the defendant unjustly enriched? And how much were they unjustly enriched? It's kind of confusing the way that put, and it made it imply that there was unjust enrichment. I think that's why the jury felt like they were compelled to put something there. And again, there should not have been a jury instruction. And I would note that Judge Moye in our post has agreed that I didn't waive that objection. And I did raise it in a JNOV, which is an appropriate place to raise it if you're trying to strike one part of the jury verdict that goes against the law. So this court has the authority to knock that down. But again, it goes back to there's no jurisdiction here. If you don't list it on the asset schedules, it's still in the bankruptcy court.
Thank you very much, Mr.
And
Walsh.
it belongs to the U.S. trustee, not.
I want to thank the parties for accommodating our technology challenges today and for excellent briefing and argument. And the case will be submitted.
Thank you, Your Honors. Thank you for your time.
Thank you all.